The California Residential Purchase Agreement form is the cornerstone of every successful real estate transaction in the state of California. In this training video, we will review how to properly complete and use the RPA form step by step to better serve and protect yourself and your clients. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. We will cover paragraphs 19 and 20. Our instructor for this video is Kevin Burke. Let's get started.
So let's talk about paragraph number 19 and number 20, and I want to show you some changes to a form that we had, which was the RCSD-B, but no changes to the RCSD-S. Let's talk about representative capacity. So a natural person, pretty easy, bleed, right? What's a non-natural person? Essentially everybody else, okay? So non-natural person can be a sole proprietorship. So again, it's not the person. It can be a trust, it can be an LLC, it can be a lot of different things. And I'm going to show you the form for doing that. And remember that while we recognize LLCs by contract, remember that the Department of Real Estate will not give a real estate license to an LLC. Interesting fact. Okay, so let's talk about representative capacity. What is happening when I am signing on behalf of another? So another person, another entity. So it could be I'm signing on behalf of another person, power of attorney, right? So I am not that natural person. I am signing on behalf of that natural person. So now I become a non-natural person for purposes of the law, okay? And so that's my power of attorney, okay? So if one or more parties, and let me pull up my annotator because you know I love to annotate. So if one or more parties is signing this agreement in a representative capacity, and that should probably be in parentheses, not for him, herself as an individual, okay? Now, remember, if you do this, you got to make sure that you continuously do it throughout the transaction. Don't switch back and forth between them signing individually versus them signing as a corporation, okay? But we'll talk about that, all right? You need to have continuous flow, okay? So that party shall so indicate in paragraph 31 and 30 or 32, okay? We're going to cover that in a minute, and attach a what? An RCSD, okay? Representative capacity signature disclosure. Now, there's no hyphen after it because it's going to apply to both sides, buyer and seller, okay? So we don't know which one it is that's going to have one. I've had transactions where both sides were RCSDs. I've had it happen where only one side was. I've had it happen where everybody was actually a natural person. But I'm going to tell you, if you're doing a transaction in real estate in San Diego County, the chances of you actually seeing someone signing on behalf of another entity, more specifically a trust, you're going to see almost half of our transactions are trusts. Okay, so you don't need to know what a trust is. You don't need to go crazy. You need to inform everybody that someone is signing on behalf of the trust, and we're going to look at the form in a second. Okay, and then secondly, you need to look at you need to be aware at least of your trust advisory form, and I like that form. When you do your offer, if you are the trust, if the buyer's a trust or the seller is a trust, you'll check the box that says trust advisory on paragraph number 5, right? On addenda, paragraph number 5, and then that will automatically pull the trust advisory into your document, into your transaction. Okay, all right, so we need to make sure that we're using current forms, and hopefully you're using the live version of zip forms, okay? All right, that being said, let's move on. So next paragraph, whenever the signature or initials of the representative identified in the RCSD appear on this agreement or any related documents, remember what I said, the chain, the flow, it shall be deemed to be in a representative capacity for the entity described and not in an individual capacity unless otherwise indicated. So very, very important concept, and I'm going to tell you why. If you take a listing, and you list the property and you have the seller sign it, but the seller is a trust and they don't sign as the trust, then you don't have a listing, okay? So what this says is everywhere that the seller signs as an individual, they are signing on behalf of their authority to sign on behalf of the trust. Okay, so I'm excited to show you the form and how to fill it out. I've had pretty substantial brokers confused by it, and you know what, and that's okay. You know, it's okay, you know, as long as you fix it, right? I mean, you got to fix it at some point. So okay, so let me get my picture out of the way here, so let's talk about that. Okay, so so the party acting in a representative capacity, one, represents that the entity for which that party is acting already exists. Now, folks, you might think that's, you know, well, that's pretty obvious. No, it's not. Okay, so if your client says, I'm going to sign on behalf of the trust, but we don't have the paperwork back yet from the county or from the trust attorney, then they're not a trust, right? The entity actually physically has to exist. We're waiting for our articles of incorporation. We're waiting for some then you're going to end up signing it either individually. And I had this, a dear friend of mine who you know, insisted that they had a corporation. I looked it up. Corporation had been disbanded, and so now they're going through all kinds of. They didn't even know, right? And so understand, I look up the corporation to make sure the corporation actually exists, because I need to make sure that I have a listing agreement with a valid client. Okay, all right. So it represents that it already exists. And then two, shall deliver to the other party and escrow holder. And this came up, I had a transaction coordinator send me an email saying I'm having a problem because the seller's agent won't give us a copy of the trust documents. So it says within 3 days after acceptance, evidence of authority to act in that capacity. Okay, so by the way, shall deliver to the other party and the escrow holder. Everybody follow me there? So by contract, they've agreed to do that. So of course the escrow officer sends them an email saying, oh, we already got what we need. You don't need anything else. And it's like, well, I don't know, that A, that might be a legal decision, but B, it might also be interfering with the contract between the buyer and the seller, because I don't know, but it says very clearly that shall deliver to the other party and the escrow holder, again, an and statement, which tells me that they both get it. Okay, both get that document that says that this individual is authorized to sign on behalf of this entity. And remember, there's always going to be a signatory. There's going to be a trust cert. There's going to be a signatory signing agent on behalf of the corporation. There's always going to be, because corporations can't sign things, right? Trusts can't sign things. So we need to have something that binds the parties. We need to make sure that the person that is sitting there telling us that they are authorized to do so actually has the ability to do it. Okay, so you know, we're not talking about capacity, we're talking about ability or authority. Okay, all right, so such as but not limited to, okay, applicable portion of the trust. So we call that the certification of the trust, or the trust cert. So my letters testamentary, my court order, my power of attorney, otherwise known as my POA, corporate resolution, or formation documents of the business entity. Now, my concern, of course, is always, you know, why would somebody not give it to you? I'm not asking for all of the governing documents of the corporation. I'm just asking for the page. It's usually 1, maybe up to 4 pages long, that says this individual is authorized to sign on behalf of the corporation to do real estate related matters, things like that. I had a really good lawsuit with this, where the individual was acting outside of their authority to act based on the documents that were on hand. So be aware that that's going to become a very important thing. And guess what? You got to share. Okay, you got to share. Everybody good? All right. So formation of documents of the business entity. Okay. All right. Questions? Whoops. Whoa. Wow. What a pizza. Mike. Okay. You guys are great. Want a pizza. Okay. Let's take a look at page 2. We're going to take a look at the signing part of the purchase agreement. So in this case, so obviously I've broken this down for you. So the representative capacity part, now we're going to talk about who is signing on behalf of the entity, whatever it is. So we're just going to assume that that's where we are, that we're going to be talking about a buyer. Okay, so the buyer. Now, if you check this box, if this person is indeed signing on behalf of an entity other than other than a natural person, then checking that box will bring the RCSD-B into the transaction. So remember, this is the buyer signing. So the one or more buyers is signing this agreement in a representative capacity and not for him or herself as an individual. Restatement of what we just read. See attached RCSD-B for additional terms. Okay, so they would sign it. So now I'm going to show you in a second what this is going to do. But the name that appears in here is going to be the name of the entity buying the property. So the Bob Trust, for example. Okay, and then that RCSD is going to say that, you know, Ralph Emerson has the capacity to sign on behalf of the Bob Trust. Okay, so the name that will appear here will be the name of whoever is buying the property. That would be consistent with the name that you had on page 1 for the buyer making the offer or the offeror. Okay, and then the date, and as you know, you can't fill in a date next to a signature. That's against the rules. But your electronic signature platform will do that for you. Okay, and by the way, the print name will be in here. Based on what you wrote on page 1 of your purchase agreement. Is everybody good so far? Because I want to show you now my next form. Okay, all right, new share. Let's take a look. So we're looking here at the RCSD B. So again, this is the one for buyers. Now I'm giving you the red line version here today, okay? But I'm doing that only to show you because you're already familiar with the form, but I want to talk to you about the changes that we made. So let's talk a little bit. So this is a disclosure. Let me pull up my annotator. This form is not an assignment. Okay, got a whole nother form for that, assignment of agreement addendum, okay? Should not be used to add new parties after the contract has been formed. This is for purposes of creating in the original agreement, okay? Purpose is to identify who the principal is in the transaction and who has authority to sign documents on behalf of that principal. Okay, again, when the principal is a non-natural person, okay? All right, let's roll it down a little bit. So this is a disclosure to one or more of the following. In your case, you don't have to do anything, but you know, today we're discussing the purchase agreement. You don't have to circle it. Don't worry about that. Specify below in, you know, identifying who is the buyer. Okay, so that's my deal. I'm trying to take care of the buyer with this form. I'll have another separate form for seller. Okay, so how do I fill this form out? All right, this is the part they never tell you in real estate school. Okay, remember the stuff you had to learn to get your license, and then you get out in the real world and all of a sudden it's like, whoa, they never told me about that. Yeah, I know. Okay, all right, I have a problem with that, but that's okay. So here are my 4 entities. I'm either going to be a trust, or I'm going to be some other corporation, an LLC, a partnership, okay, or I'm going to have a power of attorney, or it's going to be an estate. Okay, so let's talk about the 4. Because it's important. So if I name a trust, so remember up here, buyer, and again, it will have the Bob Trust, right, up here, okay? Then down here, it will say Bob Trust, whatever the legal name of the trust is, okay? Again, legal name, okay? Don't make it up, and it has to exist. And I would personally be looking at the document with the trust and say, okay, here's what I have as the name of the trust. Is that what your intention is? So I'm taking a big listing on some land right now, and the individual is holding property as a trust. And guess what? I'm gonna see the trust documents because I want to know that I have a listing. If I don't have a listing because I don't have the appropriate signing authority, and I put it in the multiple listing service and somebody brings me an offer, I may end up having to pay a commission. That's just the rule, okay? So this would say Bob Trust. This would say Bob Trust dated, right? It'll have some other identifying characteristics to it, okay? So if I check that box, then I'm gonna have that information. I need to know that I have the name of the trust, okay, the trust document, and then what that is going to be. It's very likely it'll have a date associated with it, okay? Then I'm going to have down here, person signing below is or are sole, co-successor trustees of the trust, one or the other. I'm circling it. You don't have to. I'm just letting you know that that's what it is, okay? So let's take a look at B. So again, this is a draft because this is the red line version. I'm going to show you what that means in a second. So entity, if I check that box, now is it a corporation? Is it an LLC? Is it a partnership? It's only going to be one or the other of those things, or it could be something different. which has authorized the officer managing member, so I have one right now, managing member, partner, or person signing below to act on its behalf, authorizing resolution of the applicable body of the entity described above. Please remember to check the box, is or is not attached. So did you convey that at the time of the offer? And because remember, you're representing the buyer here. Did you convey that at the time of the offer, or how long you have? 3 days to supply that to the other party and to the escrow holder, not just the escrow holder. So it's an and statement, okay? All right, paragraph number C, power of attorney, we call that a POA. All right, remember now the form calls out for a general or a specific. Most of your title companies are going to require that if you have a power of attorney, that it be a specific power of attorney for that particular, for the sale of land, okay? So, or purchase of land. So check with your title company, what is it you're going to require, but usually they're going to require a specific power of attorney. And if your client provides you with a general, you make sure you confirm with your title company what exactly that they're looking for. Okay. All right. And then again, here it is, dated, folks. It's going to have a date on it. And this is going to differentiate it from another power of attorney that might have happened at a different time. And power of attorney specifically, right? Because if I have a power of attorney dated today, it may, depending on how it's written, it may nullify all power of attorneys prior to that. All right, okay? And remember, kind of an important point, but remember that power of attorney dies with the person. So if you can only give with a power of attorney, and this is that legal stuff again, legal language, but you can only give the power that you have. So if you are held to be mentally incompetent and you give someone your power of attorney, then they too, the person with the power of attorney, is also mentally incompetent. Okay, so normally that's why we have different things that we do when we have a problem with someone who lacks capacity, as we say. Okay, good. I'm using those big 50-cent words on you here. Okay, all right. This is not a power of attorney. There has to already be one, okay, already executed, okay? This is just telling people that, clearly you do not want to have power of attorney for your client, but you would want to have a copy of the power of attorney for purposes of the transaction, okay? So, but again, this does not become a power of attorney by using this form. Power of attorneys are much more complicated than this, and they require a lot. I would recommend an attorney. Or what I would do is, if I'm doing a real estate transaction, I'll contact the title company and I'll say, send us over the power of attorney that you want us to use in this transaction, and then I'll let them talk to the buyer or the seller about that. Okay, everybody good? That's a good way to figure it out. Okay, estate. What is an estate? Well, buyer is either a conservatorship or a guardianship. So when I talked earlier about the person being incompetent, mentally incompetent, or incompetent, lacks capacity to contract, as we say, then maybe it is really, there's been a conservatorship or a guardianship that has been created for them. You will know that that's what it is because it's going to have a Superior Court case name. It's going to have a number. Okay, so you're going to know that you're in one. All right, so well, not you in one, but somebody else is in one. And I mentioned it a second ago, and I want to make sure it's very clear. Most brokers do not allow you to have power of attorney for your client. Okay, there's this little thing called conflict of interest, which says that you can't really contract on behalf of another because you're going to get money out of this. All right, so check with your broker, check with the situation. That's going to be really important. Okay, all right, so that's we're not done with it yet, but I want to show you where the change is going to deviate here shortly. So I got my buyer's name. So again, the buyer would be the name that the buyer has, that the buyer is buying the property under. So this will say Bob. I hope everybody understands what I'm saying. Bob Trust, right? Okay, and then down here, you'll have the name of the trustee, the officer, or the managing member, and then they will sign it, okay? So they will sign, actually they'll sign it up here, but they print the representative name down here, okay? So this says everywhere, and then over here, co-trustee or whatever, I don't know what's going on with my pen. So anyway, so bottom line is that the individual here is saying, I am the one authorized to sign on behalf of this entity. And it'll always be an entity, right? Because this is specifically why this form was created. Okay, all right, let me clear a little bit of this up and take us over. I don't know what it is. I'm having internet issues. I think it's the computer. Sorry, folks. So acknowledgement of receipt, that's what it used to say. Now it says by other party, because we want the seller to know that this individual signing this document is signing on behalf of the entity. Again, you're going to have some documentation you're going to have to give them. And then the only other change really in here is if there is an assignment, then at the time of assignment of the agreement, you can go ahead and use this form to accomplish. This is not the assignment. Remember, this just says that this individual is authorized to sign on behalf of the entity that is now is replacing it. Okay, everybody good? Questions? Okay, seeing none, I'm going to bounce out of here. I want to show you. Oh God, I hope you can see this. Yeah, okay, good. You can see it. Okay, so now I want to show you what the seller side looks like. And remember that the seller, we didn't do any changes in zip forms to, or at CAR, we didn't do any changes to the seller side. So same kind of stuff applies. Let's take a look. Let's break it down. So we're going to be, in fact, I'm going to make that a little bit bigger. So this one is for the seller representatives. Oops, no, I'm not going to do that. That's ugly. All right, so seller representative, this is a disclosure to one or more of the following, either listing agreement or the purchase agreement. So this obviously, seller has received an offer, the seller is an entity, and now the seller produces this document for purposes of the purchase agreement, where the seller is identified here, okay? And then I go through what's gonna happen below that, okay? So let's scroll down a little bit, and let's take a look. Once again, I'm gonna have my 4 entities. I'm going to have either my trust, and here it is. What is is held pursuant to a trust? Full name of the trust, folks. Make sure you got the entire name in there, and that this person is the sole co or successor trustee of the trust. Okay. All right. Or so that would have been number 1. So number 2 is going to be my entity again, and now. The entity is going to be one of these things. Check the box, okay, and that's either this or this or this, okay, which has authorized the officer, managing member, partner, or person signing below to act on its behalf. Okay, and then is it or is it not attached? Is the authorizing resolution attached or not? Okay, let's get into number C. There's my power of attorney again. Again, I'm going through this pretty quick, but notice that some of the language is different. This is not a power of attorney, must have already been executed. It's in bold print on this one, but it's not in bold print on the RCSDB, interestingly enough. It could be an estate, so it's either an estate or a conservatorship or a guardianship. As identified again by Superior Court case, and then you would want to put the case number in there as well, because remember, you're creating a document that purports to bind the parties, and you have the right as a real estate licensee to do that, but you want to be careful that you don't go beyond that to giving legal advice to your client. So that being said, let's take a look. So down here by the seller. Okay, and I'm going to draw a line for you. Okay, so up here, the name. So we're going to do the signature up here. Make sure you date it. And then down here, it will print the name of the person above. Okay, and then your title, co-trustee. We used to put TTEE. Y'all remember that? We just got to a point where we'd miss it, and then everybody would cry foul, especially when they're trying to get out of the contract. Okay, or get out of the agreement, right? We call it a contract when somebody's trying to get out of it. We call it an agreement when everybody's playing nice. Okay, good. That being said, no other big changes in here at the time of the listing. So the agent should have had this done at the time of the listing, and then they would provide this form for the buyer now to sign down here at the time of the sale, okay? Or at the time of some other agreement, okay? Everybody good? Follow me? All right. That being said, and I see the question. Hang on one second. And why did we attach buyer representative for it? I don't know why we did that. We attached that to the same document. So, okay, all right. Question says, is this for probate transactions too? Rory, I'm going to tell you, you're never going to get a court to sign the document. You're going to have a probate purchase agreement, or if you use the addendum, and technically speaking, yes. If it's a probate, then but there's no place for the court to sign. Court's not going to sign it anyway. We're just going to assume the court is the law, so you're not going to get them to sign this. Okay, all right. And by the way, we have a probate advisory as well. So just like we have a trust advisory, we also have a probate advisory. So do make sure that you're using those forms. Okay. So great question. Thank you, Rory. Other questions? I see anybody? Nope, not at the moment. If you got one, let me know. I'm happy to help. Okay, so let's go back in. Everybody's got that all dialed in. Let's go back into our forms. So now again, I'm looking here at my RCSD and print the name, do all that kind of happiness. And now we're going to move on to the next page. And my next page is one or more sellers is signing this agreement now. So if you don't check the box, then seller, it has to be a natural person. If you do check the box, then you're saying it's someone other than a natural person. So check the box. Again, it'll pull up the appropriate form, the RCSD S in zip forms, sitting right there ready for you to complete it. Representative capacity and not for him or herself as an individual. See attached RCSD S for additional terms. Okay, so same kind of stuff. I don't need to go through it all again, I don't think. Question, lost audio. Oh, don't tell me this. Can you all hear me or no? Oh God, don't do that. Can somebody let me know if you hear me? I guess if nobody lets me know, I guess you can't hear me. Lost audio, can hear you, all good here. Okay, thank you. I had this happen the other day. The internet was for the birds. I'm running a gig of internet and I still had problems, right? Paying all that money. Okay, if a corp or LLC, do we include title and signature? And yes. In other words, vice president or management, yes. Good question, Rory. Yes, please identify in what capacity that they are signing, okay? Thank you, Rory. You can hear me. Jean, thank you, Jean. I appreciate you being here. Question for me. Thank you, Sina. So Jean, if you have a question for me, go ahead and type it in there. I saw you raise your hand, but I don't see a question. Is there a question? Maybe you were just raising your hand. Let me know that I could hear you, that you could hear me. Okay, all right, good, thank you. Okay, so is everybody good with this so far? Again, I want to make sure you're okay because, you know, these are, I always say, and I'm preaching to the choir, I know, God love you for being here. I can tell you the time to ask the question is here, not when you're sitting in front of the client. You know, right? It's like, oh my God, what did he say? You know, I was teaching at Miracosa for 15 years, right? I had, you know, I have a whole bunch of people that I've, you know, disciples running all over the countryside here. And excuse me. And my agents would say to me, you remember all that stuff you taught us in class? I went on my appointment and everything went right out of there. I lost it all. And so my comment is always learn as much as you can as you're going. But when you get into the real world, it's kind of like learning how to golf, right? If you practice it enough times, it should come naturally, but don't panic if it doesn't, all right? That's what your broker's there for. So like our agents, when they go on a listing appointment, I'm standing by the phone. I know they're on the appointment if I'm not there with them, right? But if I know they're on the appointment, I'm sitting there watching my phone while I'm doing stuff because, you know, my agent may send me a message or might call me, and I want to make sure that you got an answer to your question. So, and Jeannie, thank you so much. You know, I appreciate you. You sent me such a nice email earlier today. Thank you for that. Alfred, question. Okay, go ahead and type it in. Yeah, I'm, you know, I don't always go on listing appointments with my agents, but if they ask me to, I will. But, you know, that's going to usually requires me actually coming out of my quarantine, as Linda has me in my quarantine. So, whoops, I just changed a bunch of stuff I didn't need to change. I am going to go to the next page there. No question, sorry. Screen is frozen. Okay, screen is frozen. Uh-oh. Let me, thank you for bringing that up. Let me see, I can actually log in. I usually have this up already, but I forgot to do it, sorry. Because I can usually see what you're looking at, and that helps me understand what the problem is. So screen being frozen is definitely not a good thing. Okay, good. Can you see me now, okay? I've got us, actually that's interesting. Now I realize you don't see the questions, so I try to repeat the questions as they come in. So Alfred, please make sure if you can't see, it might not be on my end because I'm looking at what I look like, which is not pretty, but I can see the screen. So if you still can't see it, let me know. If anybody else is having problems, let me know. Okay, joint escrow instructions. So this has to be one of my favorite things. So let me tell you a little bit of history. So back since I was brand new, and I tell you what, I'm going to bring in the one-page purchase offer for you so that you can see it. Screen is frozen. Maybe it is something on my end. No, it's not. So I have the one-page purchase agreement that I used when I was a kid doing real estate back in the late 70s. And I'll share that with you. If you want me to email it to you, send me an email, or you know what, better yet, I'll give it to SDAR, and then they'll automatically send it to you. Will they? I've already created a file. Send me an email. I'll send it to you. It's one page. I mean, if you look at it, it's scary, right? It's like, wowee. I mean, what do you put in there? Okay, so the purchase agreement you're looking at today started out as a one-page document. The middle was all blank, okay? But what we did was, as time went on and we started having, more lawyers, it started to get bigger and bigger and bigger. Today it's 10 pages, and where we're going, we kind of stopped the process now, but we were on our way to 13 pages, and then of course the panic attack hit, and now they had to focus their energies on COVID forms and things like that. So we stopped our work on the RPA probably at a good time, and we're going to pick it up again next year, and it'll be a new form will come out in December of 2021. So here we are. I'm like, where the heck are we doing? So I, of all people, should probably be the most resistant for change, right? But I am so proud of you that you are here learning what the changes are, because I know so many people. I've been in the business 30 years. I've been doing it this way for 30 years. You want to hit them, right? It's like, you need to get into the 90s. You need to start doing things the way we're doing them today. So the old purchase agreement said residential purchase contract and receipt for deposit. It used to be a receipt for the deposit, and then we would send it over. We would fax it. We'd fax it over to the escrow company, and then they would go through it, and then they would fax us back their interpretation as it sounded to them. And God help us if there was an inconsistency between our contract and the escrow instruction. Everybody's fighting about which one prevails and all this kind of stuff. So finally, CAR, in their infinite wisdom, and I think this was back in October of 2002, we finally made the decision, okay, enough. First of all, we don't take checks anymore, right? I mean, just, check with your broker, but, we don't touch checks. We let that be, money handled by the buyer into the escrow or whatever. And then secondly, now it is receipt for residential purchase agreement and joint escrow instructions. This is a huge change. Okay, now it is the escrow instruction. So your escrow company, when they get a wind of this, you send them over the form, the contract signed by the parties. You send it over, then they send you what? Their general provisions or their interpretation of, we think this is what you're telling us to do. But that's the huge separation between what we did. We created a whole new concept. We went to the escrow company. We said, what is it about our purchase agreement? We're getting tired of these fights between the discrepancies. And they said, well, why don't you just give us instructions? And so that's what we did. So this is probably one of the best contracts I think I've ever seen. We now have input from the escrow company, the lender, the title company. We have input from the lawyers. We have input from all these different resources, so that now we think we've come up with a pretty good document. And then I'm telling you, we're going to change it next year. Well, those changes are pretty significant. So, but for now, I need you to understand the concepts. Okay. So let's talk about that. Bold print, right? The following paragraphs or applicable portions thereof of this agreement constitute the joint escrow instructions of buyer and seller to the escrow holder. So when somebody says to you, well, I'm waiting for the escrow instructions, well, you're holding it. Here it is, okay? Which the escrow holder is to use along with any related counteroffer and addenda and any additional mutual instructions to close the escrow. I've had people say, gee, I didn't realize that's what that paragraph said. And it's there. We just need to read it, right? Okay, it has to be written in plain English, okay? Paragraphs, and then it lists the paragraphs, okay? Look at all these paragraphs, all these things, okay? Of the section titled Real Estate Brokers on page 10, okay? So that's what this is now going to be. So that's kind of cool. I'm excited about that, because now it says this is the escrow instruction, and it's going to incorporate all these things, okay? So if a copy of the separate compensation agreement provided for in 18A, which we covered last week, or paragraph D of the Real Estate Brokers on page 10, is deposited with escrow holder by a broker, escrow holder shall accept such agreement and pay out from buyer's or seller's funds. Remember, it constitutes irrevocable instructions, okay? Seller is signing off on it, buyer is signing off on it, okay? So this is why I tell you, you need to have an agreement with your buyer, and that's that buyer representation. We had a great class yesterday, right? The buyer representation agreement. We'll pick it up next week. If you want a copy of it, send an email, education@sdar, if you weren't there. Okay, all right. The broker's compensation provided for in such agreements. So again, if I've got a buyer representation agreement, then I'm going to send a copy of page 1 to the escrow company, and I'm going to say, pay me based on this. And then if I am the seller, and usually escrow will ask you for those things if they see a discrepancy. So if they see a copy of the listing and it says 2.5, they're going to check with the listing broker, because all they're seeing is what the compensation being offered to the buyer's broker is. And they don't know that, there's no such thing as 50-50, right? I mean, everybody thinks, oh, well, the law. No, the law doesn't say that. I mean, I've had many a listing agreement that I have seen that has the total commission being 6% or 7% or 8% or 9% or whatever number, but what I have in the MLS is only what I'm offering the other brokers. So we can't just assume that the listing is for double the amount of that, and that would be, again, a Sherman antitrust violation, right? We can't make that assumption. So that's why escrow might say, is the compensation other than split, and so like we did a couple escrows today, and they're asking us, whether or not the compensation, do we have another agreement? Like, do we have a buyer representation agreement? If I'm only being paid 3.5% on the buyer's side, but I have a buyer representation agreement that says that the buyer will pay me 5, I'm going to send that over to escrow, and now the buyer will come up with the 1.5 difference between the two to close the transaction. Okay. All right. The terms and conditions of this agreement. Terms and conditions of this agreement not set forth in specified paragraphs are additional matters for the information of escrow holder, but not about which the escrow holder needs to be concerned. So, anything else in there, they don't need to worry about it. Okay. All right. So, buyer and seller will receive escrow holder's general provisions. I said that a minute ago, if any, directly from escrow holder. It's likely, in case they're going to have their "please don't sue me" language. I mean, everybody does it, right? And will execute such provisions within the time specified in paragraph 7C1. So to the extent the general provisions are inconsistent, this was the problem, or conflict with this agreement, the general provisions will now control. Now, in the old days, we didn't have that language, so it was a crapshoot, right? Okay. As to the duties and obligations of the escrow holder only. Follow me? So if there's a discrepancy between what escrow says and what the contract says, then escrow is only concerned about their escrow instruction if everybody else has signed it. Okay. Buyer and seller will execute additional instructions, documents, and forms provided by the escrow holder that are reasonably necessary to close the escrow, and as directed by the escrow holder within 3 days. Okay. So if you're doing a short sale, then you might want to change that time period. Shall pay to the escrow holder or the HOA or the management company or others any fee required in 7 or 10 or elsewhere in the agreement. Everybody good? Questions? Whoops. Alfred, are you able to see the screen again? I hope you are. Okay, nobody else said that they were having trouble, so I'm hoping Alfred's okay. Okay, all right. If we're all good with that paragraph, let's move on to the next one. And it's probably Alfred. Mike, you're good? Okay, thanks, buddy. Okay, all right. Alfred, you're good. Oh, logged in, logged back out. Yeah, smart. Sometimes that happens. I had to do it the other day. I was doing the webinar, and I had to log out and log back in. It made me insane. Okay, anyway, bad internet. Okay, so let's talk about a copy of this agreement. Okay, so back to my annotator. A copy of this agreement, including any counteroffer and addenda. So this document, which is the RPA, shall be delivered to escrow within how much time? 3 days after acceptance. Remember, that's why acceptance is so important. So I was having this conversation with Linda the other day. So you have offer, you have acceptance, and then you must have, in order to have a contract, you must have delivery back to the parties to be bound. So no contract until you have delivered the intention of the signing party. So that way you now have a meeting of the minds. But for our purposes of our contract, assuming that we've done that, because remember, if the buyer makes an offer, seller signs it and says, I agree to the deal, but then throws it in a drawer and doesn't communicate their acceptance to the buyer, then no contract, right? There's no meeting of the minds, okay? So what this is saying is now let's talk about things in terms of acceptance. So the problem, the situation that we were having was, okay, so when do your contract periods begin? And the answer is not necessarily when communication, delivery of a confirmation of acceptance, but when acceptance. And that's what this says. It doesn't say confirmation of acceptance, it says acceptance. So, the agent that dallies on this is making a mistake. You need to get that back to the other guy right away. Let them know that you have confirmation, because that acceptance time is when the time periods are ticking. And if you're holding on to the acceptance, you may be causing harm to the other party, okay? You might actually be interfering with your own contract, and that's a legal term, okay? All right, so we want to be very sensitive to that. I had a similar thing happen the other day where a transaction coordinator told me that they would hold all of the disclosures, not send them over to the buyer until they had a complete package. Well, I don't know. I think that when I send, and by the way, we send things only to the agent. We'll copy the TC if the agent gives us instructions to do that. But remember, you are the captain of the ship, so you are responsible. And so we're not sending stuff only to the TC, okay? Because the TC is TC, right? And we have an obligation to work with the agent, okay? And so that's what we're going to do. So date for acceptance becomes very important. And then when we start talking about giving the buyer disclosures, don't be holding on to those things, because some of those disclosures have statutory rights of rescission. If you hang on to them because you're waiting for other forms to come in, then you might be taking away your buyer's ability to rescind the contract. And so there's going to be some serious legal problems with that. And I'm probably going to bring that up in our risk management meeting next week, because I've had that happen a couple of times and it makes me nuts. It's like, listen, don't be holding things up. You have an obligation. You are the messenger. Bounce it right away to your client. Don't be sitting there deciding when you think it's appropriate. And certainly as the agent, you know that you have received it. The clock is ticking from when you get it, okay? Because you are the agent, all right? And so the clock is ticking, all right? So anyway, check with your broker. But I have some very interesting conversations. Linda says I make them cry, but I'm not trying to do that. Okay, so all right, so now here we go, or whatever date, okay? So buyer and seller authorize the escrow holder to accept and rely on copies, okay? It used to be that they could only act on the original. In fact, it used to be you could only sue on the original, okay? And signatures as defined in this agreement as originals, okay? All right. So that's, I know you get a little, we'll take you down memory lane here, to open escrow and for other purposes of escrow, okay? All right. Those are some pretty powerful legal terms. The validity of this agreement as between the buyer and the seller is not affected by whether or when escrow holder signs their agreement. So as you know, escrow signs on page 10, acknowledging receipt of the deposit, acknowledging receipt of the instructions to conduct the escrow. It does not impact the parties. It just says this third party, let's not make them a deity, okay? This third party escrow, when they get it back to us, it doesn't have any impact. We don't start any time periods based on that, okay? And if you are starting time periods based on when escrow signs their part, make sure you're talking to your lawyer, all right? Okay. Escrow holder shall provide seller's statement of information to the title company. Okay, so the seller's statement of information is something that the seller agrees by contract to return within a specified period of time according to the contract. Okay, when received from the seller. So we fill it out. It came from title. We fill it out. We give it to escrow. Escrow then forwards it on to title. And by the way, they forward it on now, not a week from now. Okay, I've had that experience. If the seller delivers an affidavit to the escrow holder satisfying FIRPTA, okay, under 10C, all right, then escrow holder shall deliver to buyer a qualified substitute statement that complies with federal law. So remember, we have state FIRPTA, we have California FIRPTA, and we have federal FIRPTA, okay? And so those are very important distinctions. So when we do our FIRPTA form, we're taking care of the national portion of things. And now we've gotten into the practice, instead of collecting the seller's social security number and things like that, we have that information go straight to escrow because it's privacy issues. And then escrow sends us a qualified substitute form. It's a CAR form QS that says we've got their social security number, and that should make you happy. Okay. All right. So that's what this paragraph says. This paragraph says that escrow holder statement of information, very important. We need to know that, in fact, we need to determine that this is in fact the seller, and they dig deep on this. Okay, they're going to give it to the title company when received. Okay, and then if the seller delivers my FERPTA, then that satisfies paragraph 10C, then escrow holder shall deliver to the buyer a QS form. So this is going to be my QS. Okay, everybody good with that? All right. Remember, your FERPTA state law in California is 3% of the purchase price, or 9 1/3% of the gross profit. The Fed changed January of last year to 15%. And all of those are just to make sure, obviously by the government entities, that they get their due at sale. And if the seller is going to be removed, and I'm not going to give you tax advice, but if the seller is relocating within California, then there shouldn't be a California withholding. You'll have to, it's going to depend on the buyer. But if the seller is moving to Japan, or now you had mentioned a country because somebody's going to get offended, or China. Okay, if they're going to move out of the country, then California is going to want a withholding, and so will the Fed. Okay, unless they have the proceeds check going to someplace that's local. Okay, everybody good with that? Doesn't look like I'm going to have to get into a long conversation about FERPTA. Okay, all right. That being said, let's go to my next page, and that will be my paragraph number C. And this is kind of fun because people ask me these questions. They say, where is the part in the contract that says that, we're only here for purposes of compensation, things like that. So brokers are a party to the escrow. Okay, remember, we are not parties to the escrow for the sole purpose of compensation. Is that okay? All right. We're only in the contract because we want to make sure we get paid. All right, and so this is the instruction to escrow that says, pursuant to paragraph 18A, back there, remember, and D of the section entitled Real Estate Brokers on page 10. We call that the broker box, right? So that's the broker box, okay? Buyer and seller irrevocably assigned to the broker's compensation specified in 18A, and irrevocably instruct escrow holder to disperse those funds to brokers at close of escrow or pursuant to any other mutually executed cancellation agreement. Okay, so bottom line is, this is the power that the escrow has to follow that instruction to pay compensation. Compensation instructions can be amended or revoked only with the written consent of the brokers. All right, so escrow gets their instruction up front, how much we're paying you, out of seller's proceeds, buyer's contribution, whichever, and it can't be changed by anyone except the brokers. That's what it means when it says irrevocably instructs escrow holder. Okay, all right. So they can be amended or revoked only with the written consent of the brokers. Okay, buyer and seller shall release and hold harmless. There's our famous "please don't sue me" language. Hold harmless the escrow holder from any liability resulting from escrow holder's payment. So, in other words, the buyer and the seller are giving you instructions to send the money to the brokers. You're going to have a hard time suing the escrow company because you did what you instructed them to do. Does that make sense? Everybody good? Okay. All right. Good. Questions? Seeing none. Let's move to what I believe is the last page. Okay. So this is the last page of 20, right? We're in 20? Good. I guess I should look. 20. Good. Yeah. Figured we were in 20. What was I thinking there? Okay. So upon receipt, let me get my drawing tool going. Upon receipt, the escrow holder shall provide the seller. Now this is cool. I like this. This was a good addition. So escrow holder shall provide the seller and the seller's broker verification of the buyer's deposit pursuant to 3A and 3B. Okay. So in other words, when you get the money from the buyer, you will notify the seller and the seller's broker. I almost never see it happen, okay? Except when I'm using my escrow companies. You know, when we're using the escrow companies I'm familiar with, they notify me right away. We got the buyer's deposit. Here's our signature on page 10, verifying that we've accepted the deposit on behalf of the seller, or you know, behalf of everybody, right? Because once it goes into contract, now that money belongs to no one. Okay, all right. Once the escrow holder becomes aware of any of the following, so remember at this point, we're only notifying the seller and the seller's broker, okay? We're assuming that the buyer and the buyer's broker are speaking to the buyer, okay? Once escrow holder becomes aware of any of the following, escrow holder shall immediately notify all brokers. So one, if the buyer's initial or any additional deposit or down payment is not made, right, didn't send it, never came in, or is not good at the time of deposit. All right, it happens. Buyer sends in a check, check doesn't clear. Now they got to notify everybody. Escrow holder's going to let everybody know I don't have the earnest money deposit, I don't have the initial deposit, I don't have the increased deposit, I don't have a later deposit, whatever you want to call it. So now they've got to notify everybody, because guess what? It's everybody's business. Does the listing agent, so Linda, does the listing agent still have the seller fill out the FERPA form without the SS number? If you're going to have the QS, yes, when they list the property, or we only use the escrow form. So here's the thing. That is going to be the federal form. It says right on the FERPTA that we're not providing the Social Security number. We're giving it, it'll be done, you'll get that information from the QS form, which will be the qualified substitute form. If the seller doesn't want to do that, and the seller wants to fill out the FERPTA and put their Social Security number on there, okay, remember the original legislative intent, the original FERPTA had both the California and the Fed on it. And the original FERPTA, the legislators created the FERPTA. You go to the civil code and you will see there's the form. We just copied it and put our letterhead over it, right? California Association of Realtors. That's how we handled it, okay? But you know, that was the original thing. And the original thing, it had the Social Security number. Well, we as a realtor body were up in arms. We're like, wait a minute, we don't want that information in our file. You don't want people's personal information and the Social Security number. Now you're on your way to identity fraud, and we don't want to be complicit in that. So we don't like that, okay? That's why I tell you not to give your computers to the high school, you know, until you have scraped the hard drive, because you want to make sure you don't have any of that personal information of other people on your computer, okay? And it's not, you know, my little brother does the network security for the government. I mean, for 40 years, my little brother, right? And so, you know, he takes the hard drive out of the computer and takes a Brillo pad to it. I'm like, I think that's kind of overkill. But, you know, he says there ain't no way you're recovering anything from this. So, you know, he's good. He knows what he's doing. So the answer to your question, Linda, is that I don't put Social Security numbers on forms. I don't want it. I want somebody else to take care of that responsibility, because then they become the problem, you know. And that's why I say be really careful about who you use for escrow companies and title companies. Make sure they know what they're doing, okay? Just because they're a legitimate company doesn't, you know, or I'm sorry, that they're available doesn't mean they're good, okay? So hopefully I answered your question. Okay, so my first scenario was that either the deposit is not made or is not good at the time it is made, and that happens more than you think, okay? But our contract by default says electronic funds transfer. We had to use that language because wire transfer is just one form of electronic funds transfer. The electronic funds is the bigger picture. And so, but we've had it happen where the buyer doesn't send the money in, you know, or they're trying to renegotiate the deal and they don't have the money yet. They think they have some kind of power. I'm sorry, you've already got a contract. You know, the deposit, you know, what am I looking for? The earnest money, as it were. You know, you need to have consideration in a contract, but remember that the law says consideration is an exchange of promises. The money is just something that we deceived you about. We told you that money was consideration. It is a way of consideration, but the fact of the matter is, I promised to buy your house. If you promise to sell it to me, that's all I need for contract. Okay, so, but if the money's no good, that's usually a heads up that there's a problem. Okay, and so again, the money doesn't show up, or the check shows up, then they put it in the bank. 2 weeks later, the bank, they get it back from the bank saying that it didn't clear. I want to know about it. And so escrow is given an instruction here that if that happens, everybody knows about it. We're going to tell everybody about it, okay? And then, or here, if the buyer and seller instruct escrow holder to cancel. Okay, so if there's a cancellation, then they're going to notify everybody. Okay, everybody good? That was a really good question, by the way, Linda Dugan. That was a really good question. Thank you for that. Yeah, I'm a big guy on identity fraud. We don't even order, we do a lot of property leases. We don't do management, we do leases, and we don't even order the credit report anymore. I don't want it, right? So SDAR has a really good program, a really good vendor that will order it, and everything goes between the tenant and the owner, and I'm out of it. I don't want that in my file. Remember, you're obligated to protect that file. So if you've got a hard document that has somebody's personal information, make sure that gets over to the broker. That's the broker's information to have, and they need to be locking it up. That's why the DRE requires that if you have paper files, that they're in a locked up key. I did a DRE review for a broker a couple of years ago. Got into the broker's office. They had a two-drawer filing cabinet with papers in it, you know, with personal information, and the keys were hanging out of the door of the filing cabinet. And I said, the DRE is coming in here tomorrow. You don't want them to see those keys in the door, because they're going to say that's not a locked filing cabinet when you got the keys in it. And so, needless to say, that was a really clean review. So, you know, if you're ever worried about what the DRE is looking for, and listen, I just had an email with a guy. I love the DRE, right? It makes it nice for me. They've got plenty to do out there, but you know what? It's nice to have somebody that's keeping an eye on what everybody's doing. Okay, it's important. All right. So it's no secret. I love the DRE. Veronica Kilpatrick. Yeah. She's awesome. Okay. All right. So let's take a look. A copy of any amendment that affects any paragraph of this agreement. So when you guys amend the contract, escrow needs to get a copy of it. Okay. So please, I hear this all the time. We'll call escrow and have them draw up an amendment. No, the escrow can amend their instructions. They can't amend the contract between the parties. That's legal advice. Think about it. But you're going to hear the veteran agent say, oh, we'll just call escrow and have them draft up an amendment to the contract. That would be legal advice. They don't have E&O for that. They can amend the instruction for escrow, but they can't amend the contract between the parties. So please, you draft the amendment. You take care of that. You make sure that after all the parties have signed it, you now send it over to the escrow company. I know brokers have been in business a long time to understand that concept. They're still saying things like, we'll just have escrow draft an amendment. Okay, it does not amend the contract between the parties, so you might have a conflict. Okay, all right. For which escrow holder is responsible, shall be delivered to escrow holder within how many days? 3 days. 3 days is just a magical number. A lot of what we do is 3 days. You know, you have 3 days by DRE regulation to get all material facts incident to a transaction to your broker. Okay, so, you know, email within 3 days maybe. Not like when I was management, you know, I had people coming in handing me a file, and I go, what's that? And they go, well, this is closing today. I want to get paid. Well, then you clearly did not get us the documentation 3 days after it was created, right? So then you're waiting for your check. Okay, now we don't have that problem today because all of my agents do everything by, you know, zip forms. So I have broker versions, so I can see right when they do it that they did it. Okay, so satisfies broker review, okay, according to the DRE. All right, any questions about any of that? That was a pretty powerful paragraph if you think about it, okay? That was a really powerful paragraph. So, you know, I want to make sure that you understand that DRE requires that you get anything material to a transaction to your broker within 72 hours. Your broker's contract with you can amend that, but only for a lesser period of time. So why does the DRE say you have to get anything material to the transaction to the broker within 72 hours? Because the DRE allows the broker 5 days from the time that you put everything together. So that means brokers now got 2 more days to review and determine if they want to move forward with the transaction. That's one of the reasons why, okay? So your broker, so like in our office, you know, we go, DRE says 72 hours. We say 24. We can't say 124, but we can say something less than 72 hours. And for our purposes, it's 24 hours because we're going to have it instantly anyway, because you're going to put it in the zip forms account and we're going to see it. Okay, so we've got it instantaneously. We don't have to worry, but we do have a requirement for 24 hours. Okay, everybody good? All right, questions about any of that? I told you I can make 19 and 20 where you have nothing to do, but you always wondered, what do those paragraphs mean? What do they say? Okay. Thank you all. Take care for now. Bye-bye.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.